You said just a short while ago that this presented, COVID presented a grave danger to people in the workplace. In a few minutes, we'll hear an argument in the CMS case, and it will be that it presents a grave danger into Medicare and Medicaid facilities. Not here, but in the lower courts, the federal contractor mandate, the argument's going to be it's a grave danger to federal contractors. Could you give me examples of some federal agencies where you would be willing to say COVID is not a grave danger in that context?
Well, Mr. Chief Justice, I haven't, of course, surveyed the landscape of all of the different authorities that federal agencies can invoke.
Well, but you represent them on a regular basis, you hear, so you have a pretty general idea of some other examples of federal agencies. And my point, obviously, is that I don't think as more and more mandates and more agencies come into place, it's a little hard to accept the idea that this is particularized to this thing, that it's a OSHA regulation, that it's a CMS regulation, that it's a federal contractor regulation. It seems to me that the government is trying to work across the waterfront, and it's just going agency by agency. I mean, this has been referred to, the approach, as a workaround, and I'm wondering what it is you're trying to work around.
What we're trying to do here, and what OSHA did, was rely on its express statutory authority to provide protection to America's workforce from grave dangers like this one. So I take the point and don't dispute that COVID-19 is a danger in many contexts and falls within the jurisdiction of other agencies as well. But I think to suggest that because this disease is so prevalent, because it presents such a widespread harm, somehow OSHA has less power to do anything about it with respect to
No, it's not so much that OSHA has less power. It's that the idea that this is specific to particular agencies really doesn't hold much water when you're picking them off one by one. I think maybe it should be analyzed more broadly, as this is in effect an effort to cover the waterfront. I'm not saying it's a bad thing, but I don't know that we should try to find, okay, what specific thing can we find to say, oh, this is covered by OSHA? What specific thing can we find that say that this is covered by the hospitals? What specific thing can we find to say, oh, no, we're doing this because this is a federal contractor? It seems to me that the more and more mandates that pop up in different agencies, it's fair. I wonder if it's not fair for us to look at the court as a general exercise of power by the federal government, and then ask the questions of, well, why doesn't Congress have a say in this, and why doesn't this be the primary responsibility of the states?
Congress absolutely has a say in this, and it spoke here. It passed the OSHA Act and promulgated Section 655C specifically to empower OSHA to take action to protect workers from grave dangers.
When did it do that?
The OSHA Act was enacted in 1970, I believe, and the agency, as it explained in the preamble to this rule, documented substantial evidence to show why this constitutes a grave danger.
Well, I don't think you can say that that's specifically addressed to this problem.
Well, Mr. Chief Justice, the court obviously has a statute in front of it that it needs to examine. I think that there is no doubt that COVID-19 constitutes a physically hazardous agent within the meaning of this provision. I think that the immediacy and magnitude of harm here clearly constitutes a grave danger. Unvaccinated workers stand a 1 in 14 chance of being hospitalized, a 1 in 200 chance of dying. The country hasn't seen numbers like that.
It sounds like the sort of thing that states will be responding to or should be, and that Congress should be responding to or should be, rather than agency by agency, the federal government, the executive branch acting alone is responding to. And we're supposed to say, well, yes, this is a CMS problem. Yes, this is an OSHA problem. Yes, this is a federal contractor problem. The military is on its own. They take orders. Again, I guess I'm just repeating myself. It seems to me that we should be looking at it as an across-the-board issue, as opposed to, let's see what OSHA looks like. Let's see what CMS looks like.
Well,
General, I'm sorry, go ahead.
Go ahead.
I was just going to say, Mr. Chief Justice, that I think the court, in approaching issues of statutory interpretation and looking at agencies' regulatory authority, has always started with the text that Congress enacted for purposes of understanding whether the agency has power to act. And the fact that there are other agencies here that likewise we think are empowered to act to protect America against what is happening in this country right now shouldn't diminish the force of the express statutory authorization here.
But I think the question is this. I mean, it is a rather deep, in a sense, deep question. Can you, or maybe you did, could the White House say, issue an order to all federal employees And what it says is every federal employee in any agency who has authority under a statute, which means all of them, to require those whom they regulate to insist that their employees be vaccinated, do it. Now, they can't legally tell you do it, but it's a strong policy. And that's what's happened. Now, I don't know the implications of that. I never thought of that. But I think that's what you're being asked, is that, if that's, and I don't know you ever thought of it. But I mean, has that happened?
I think it's incorrect to say that that is what is happening here. This policy clearly...
Yeah, but I mean, has that happened generally? Has that happened? Did somebody issue such an order?
Justice Breyer, standing before you today, I'm not sure that I can think of a precise historical example of that
No,
kind
I
of
mean,
order.
in this instance, your answer, I take it, is no. There is no such order.
That's right. I mean, certainly, I think that that throughout this nation...
I don't want to put words in your mouth. Don't tell me there isn't such an order if there is.
No, I'm not aware of any such order.
All right, or something like that. Okay. I have one other question for him, which is because I'm operating between two things. One is the merits, which might be difficult. I don't know. I'm not taking a view on that. But at least they're difficult and could take time. And the other is the question of the stay. Now, on the question of the stay, I read from research that we've done, but I don't know if it's right, that the argument was, what about the argument that they've made? One is that, well, if we issue a stay today, tomorrow, more people will stay home and things will get worse. See? That was one of their arguments. And the other, well, all right, what about that? That seemed to me to be the main one.
As I understand the argument, they're concerned about worker attrition with respect to that particular claim. Yep. And the agency gave sustained attention to this very issue. It spans several pages of the Federal Register. The agency looked at surveys that attempt to analyze how workers will respond. It looked at the real, on-the-ground, practical experience of companies that had imposed these kinds of mandates and found that there was substantial compliance levels and that the concern that workers would leave in droves was misplaced. And then the agency further emphasized that it had provided flexibility to employers to adopt a mask and test policy instead of a vaccination requirement, specifically because the employers are best positioned to understand their workforce and to know which of these options is going to ensure maximum compliance.
What about on the merits? I just have one other, which is on the merits. You've heard and you've read the argument on the other side that, look, what the OSHA could easily have done or should have done is go through industry by industry or groups of industries by groups of industries and say there's this here and there's that there. Instead, what they did is everybody over 100 employees, except for, and then they had a few exceptions, working alone, working at home, religious exemption. You can prove to us that you have some other thing that's just as good. You know, they went that way across industries instead of one by the other. That's one of their arguments. What would you say to that?
My response to that is that the Secretary here cited overwhelming scientific and medical evidence that the grave danger exists based on how this virus is transmitted anywhere people gather indoors together. And that applies to a lot of workplaces, but that just turns on the nature of how this virus is communicable between people. As Justice Kagan noted, often employees have little control over their work environments. They can't control whether they can socially distance, who they come into contact with, what precautions those people are taking, what ventilation systems exist. And ultimately, OSHA determined that anywhere there is a risk of indoor transmission, there is a grave danger to unvaccinated employees. Now, I take the point, as the Chief Justice's hypothetical focused on, I think Justice Barrett focused on this as well, that there are certain workplaces, factories, assembly lines, where the risk is even graver, where the danger and the chance of transmission is heightened. But I don't think that that in any sense calls into question the Secretary's determination that there is a baseline grave danger in any work site where that inside risk of transmission can occur.
General, can we, I'm sorry.
Counsel, in which case is the relationship between the agency closer to the COVID-19 danger? In this CMS case that you're arguing before us now, or in the OSHA case that your boss just finished arguing?
I think they're different cases. I think it's hard to say which one is closer. The OSHA case, the OSHA Act gives the Secretary of Labor responsibility for workplace safety, and you just heard why the COVID-19 pandemic is a grave threat in the workplace. CMS has authority to protect the health and safety of patients in Medicare and Medicaid, and explained at length why the COVID-19 pandemic is an acute danger to patients in that setting. So I think they're both very close.
Well, maybe it expands it. Which is a more acute danger? OSHA, CMS, or the federal contractor vaccine mandate?
Well, I think all of them. I think this gets to the question you asked my boss earlier, which is, the government is doing a lot of things in response to the pandemic, and I don't think that's a surprise. This is an unprecedented pandemic that touches virtually every aspect of American life, and so it does affect the authorities of lots of different federal agencies.
Do you think the government has picked the three most pressing areas to address, and they're doing it in order? Or why OSHA, why CMS, why federal contractors, why not any host of other areas that are also, where COVID-19 is also a serious problem?
Well, because the federal government is, as some of the questions earlier have suggested, a government with limited powers. The federal agencies have the authorities that Congress has given them. Congress has made OSHA responsible for workplace safety. Congress has made CMS responsible for Medicaid and Medicare patient safety, and those agencies have determined and explained their conclusions why those authorities are called upon here by the sort of unique threat that the COVID-19 pandemic poses in both contexts.
I thought you might have said, and it may have been uncomfortable, but I thought you might have said we're dealing here in this case with health care, with Medicare and Medicaid, and what could be closer to addressing the COVID-19 problem to health than health care? I mean, people already get sick when they go to the hospital, but if they go and face COVID-19 concerns, well, that's much worse. On the other hand, OSHA, it's workplace. Yes, COVID is a problem in the workplace, and in some situations it may be a more serious problem. But it seems to me that if any of the three that I've been talking about anyway present a close connection, it would surely be between a health threat like COVID-19 and the government's health care.
Mr. Chief Justice, I certainly don't want to disagree with that at all. I think there is an acute threat that COVID-19 poses in healthcare settings. We've seen that throughout the pandemic, especially in nursing homes and other congregate care settings, which are within the scope of this rule. I absolutely agree that Americans shouldn't be forced to choose between getting medical care and exposing themselves unnecessarily to a virus. And as we explain, healthcare workers have long been expected to take extra precautions, including vaccinations, in order to prevent them from infecting their patients. So I don't disagree with any of that, but in making all of those points, I don't want to undersell also everything you heard about in the first case about the grave danger that the pandemic poses for workers as well, in a way that implicates OSHA's authority too.
Counsel, there is another significant difference that you haven't talked about. This is a spending clause case and not a general powers case. And I always thought that when you're talking about spending clause, that the government has more power to define where it wants to spend its money, correct?
Absolutely.
And to that extent, one of the major arguments raised by the other side here that I want you to address is what they describe as the...
In Carney against Adams is a lot more concrete than your First Amendment hypothetical. I mean, these cases are hard enough when you're trying to figure, well, what is the weight of the infringement on the First Amendment values, against what is the protective effect on potential corruption. I mean, I don't know how you do that in the first place, but to say that the standing is going to depend upon a particular calculation, I think it's much more concrete in Carney against Adams when you're asking, well, would somebody really go to, go run for office? That's also hard, but not anywhere approaching the indeterminacy of the calculation we're supposed to make here.
Well, I think the calculation on the merits may be difficult and it may involve a complicated balancing, but the calculation on standing, I think, is very straightforward. If the appellees had filed their suit 7 days before the election and they had said in their complaint, Senator Cruz has no intention of loaning money to his campaign regardless of the outcome of this suit, but he feels strongly that the statute is unconstitutional and he would like a judicial determination to that effect. Clearly there would have been no standing, whatever the court thought of the merits of the constitutional claim. And what we have here is essentially that. That is, appellees have stipulated that if there were no statute, if there were no reg, they never would have made the loan and they would have promptly repaid it if the loan had been made. And so the
Well, it's just sort of, I mean, there's test cases are not always, you don't always have a lack of standing. If you get people challenging discriminatory housing practices and they go in and say, you know, we're thinking about buying this house, and they're discriminated against because of their race, they don't say, well, you know, whatever, you can't buy the house. They don't have to go in and prove that they would actually buy the house, do they?
Well, if they might not have to prove that they would buy the house in the same way, for instance, that in the school admissions cases where you have use of racial criteria in school admissions. The plaintiffs don't have to show that they would have been admitted if the laws were different, but they do have to show they were ready and able to apply. And the question here really is, if they didn't have standing 7 days before the election, can they manufacture standing by voluntarily subjecting themselves to an injury solely for the purpose of facilitating a lawsuit? I mean,
Mr. Stewart.
Thank you. Thank you, Ms. Theodore. I just have a couple really quick questions. It's maybe along the same lines as Justice Alito's, but it does seem a little unfair to me that you're asking us to pick your opponents. I'd rather, in court, I'd rather have only one person arguing against me rather than two. But I think that's a little bit of a conflict there. I mean, what are you afraid of? I mean, I'm sure you could handle two of them as easily as one.
Well, I'll say again that we haven't picked our opponents. We sued the people who federal law, Ex parte Young, and Article 3 allowed us to sue. So we didn't make a decision there. But, you know, I think what Rule 24 is about is simplifying litigation, and it says we don't add another defendant, we don't add another plaintiff unless there's a really good reason. And here there is one.
You keep saying we. I mean, the point is that it's a court interest, and the question is whether the court should be letting the state have the two representatives that under state law they say they should have. And I mean, I don't mean this the way it might sound, but I don't know why we're terribly interested in what your views are on that in the first place, because you're the one who's going to benefit if we throw one of your opponents out.
Well, I think Rule 24 is there to protect plaintiffs and defendants. It's there to simplify litigation. It's there to reduce cost and burden, and that's an interest that protects the litigants, including us. I think, you know, we have an interest, and I think the court probably should have an interest in sort of not announcing rules that make it easier for governments to just say we're going to make it harder for people to challenge the government. So I think we do, as plaintiffs, have an interest.
Thank you. Justice Breyer, anything?
Well, I'll go back to this once more.
General, you have emphasized the service academies today, and you did in your brief, and Government Counsel and Grutter did as well. Are you linking yourself to Harvard and UNC? In other words, you rise or fall with their case?
Well, Mr. Chief Justice, we certainly think that it's critically important for universities throughout the nation to be able to prioritize the educational benefits of diversity, and the ROTC programs are also a compelling interest for us here that exist at those civilian institutions. But I guess if what you're asking me is whether we think the military has distinctive interests in this context, I would say yes, and I think it's critically important for the court in its decision in these cases to make clear that those interests are I think, truly compelling with respect to the military.
So in that situation, I suppose it depends how significant you think those distinctions are. It might make sense for us not to decide the service academy issue in this case?
Well, I would certainly ask the court to take account of those distinctive interests and I think to recognize the compelling interest and the critical national security interest that I think.
I guess I'm saying I would have thought that you might want to distinguish yourself in order to preserve arguments that are particularly applicable, if there are such arguments, to the service academies, rather than take the position here, which is you're going to be bound by whatever we say with respect to the other universities.
Well, it is critically important to the military to be able to achieve diverse student bodies in the service academies, but it's also critically important because actually more officers come from ROTC programs to try to protect and preserve space for universities to also achieve the educational benefits of diversity and provide the path to leadership that inhere in those programs as well.
We'll get to you in a moment. There's been a lot of talk about African American applicants to Harvard in sort of a general, indistinguishable way, when in fact they cover a very broad swath of applicants.
Of course.
What do you do with respect to an African American applicant? I mean, you're concerned about diversity of viewpoint. Let's say his viewpoints tend to be very close to, the white applicants. He grew up in Grosse Pointe, had a great upbringing, comfortable. His parents went to Harvard. He's a legacy. And yet, under your system, when he checks African American, he gets a tip. He gets a benefit from that. Isn't that very stereotypical under the Harvard program?
I think it's well, first of all, it is simply not the case that every black applicant gets a, quote, tip. In fact, I'll direct the court's attention to page 1,811 of the joint appendix, which includes this beautiful chart, which represents an undisputed model of the relative importance of race on application outcomes. And the one that you cannot actually even see to your far right is race. Race explains.
I can't see it because it's far away.
Nonetheless, you have the page reference.
It is not zero.
It is very close to zero. That is, the testimony in the case was.
Well, so there's only a little racial discrimination in the case.
Are you asking me whether Harvard is, you're asking me to answer a question that assumes that Harvard is discriminating on the basis of race? No, I can't accept that.
Well,
what Harvard
isn't that what is, Mr. Waxman, isn't that what the case is about, the discrimination against Asian Americans?
There was count one of the complaint was that Harvard was intentionally discriminating against Asian Americans. The entire evidence of that case, all of the plaintiff's proof, was that Asian Americans are treated worse than white applicants. That is, that there was prejudice, intentional discrimination. The evidence could not more soundly have refuted that.
Charts? What do you do with the charts in their brief? I think they're on page 24 or 43, the academic decile and the comparative treatment of African Americans, Hispanics, and Asian Americans. You don't see a surprising disparity in that?
So there's a lot to be said about that, but I guess the first thing I would say about that chart is that their own expert agreed that because that chart is simply a descriptive statistic, it is, quote, not equal to evidence of discrimination. It reflects a pattern which might or might not be real. Now, understand that that chart that they've displayed for you, they have eliminated all ALDC applicants. So 1/3 of the admitted class over 6 years, they're not even in that chart. That chart is predicated on something called an academic index. An academic index is a formula that looks at two things: high school grades and test scores.
And so people in the different racial categories, they have a different result based on other factors, which include race.
They have a different result because among the many, many, many characteristics of any particular individual applicant that Harvard considers, one that it does not consider is the academic index. That is the very metric that they're displaying for you. Harvard doesn't even use the testimony in the case was the only reason that the academic index is even calculated is because the Ivy League athletic rules require that your recruited athlete class, the AI for your recruited athlete class, not be more than 2 standard deviations below the matriculating class last year.
Put aside the hypothetical about the African-American applicant who's a legacy. Take 2 African-American applicants in the same category, however you want to take it. They both get, or both can get, a tip, right? based on their race. And yet they may have entirely different views. Some of their views may contribute to diversity from the perspective of Asians or whites. Some of them may not. And yet it's true that they're eligible for the same increase in their opportunities for admission based solely on their skin color.
So the point...
That was a question.
No, I know. I'm attempting to answer your question. There is no doubt that as the testimony showed, that for applicants who are essentially so strong on multiple dimensions, so extraordinarily strong on multiple dimensions, that they are sort of on the bubble, that they are a real candidate for admission, being African American, or being Hispanic, or in some instances being Asian American, can provide one of many, many tips that will put you in.
People say that, yes, but you will have to concede that if it provides one of many, then in some cases it will be determinative.
I do concede that.
Okay, so we're talking about race as a determining factor in admission to Harvard.
Race for some highly qualified applicants can be the determinative factor, just as being an oboe player in a year in which the Harvard-Radcliffe Orchestra needs an oboe player will be the tip.
We did not fight a civil war about oboe players. We did fight a civil war to eliminate racial discrimination, and that's why it's a matter of considerable concern. And I think it's important for you to establish whether or not granting a credit based solely on skin color is based on a stereotype when you say this brings diversity of viewpoint. It may not bring diversity of viewpoint in a particular case at all.
Well, number one, viewpoint diversity, while Harvard values it and seeks it, is not the only by far the only reason for wanting a genuinely diverse class. We want a diverse class for backgrounds and interests and lots of things other than just viewpoint. If we were to use, for example, the example that has been discussed, I believe, for every other advocate that has stood up this morning, and ask, what about taking race into account if the student writes about it? The fact of the matter is Harvard is attempting not to have, among a class that is diverse among many generations, a class that is racially diverse only for people for whom their racial identity and their racial experiences is of such compelling importance that they write about it. Right? Your hypothetical about the black student who may have very different views than the stereotype of what a black student will have is in fact the subject of that's discussed in the Corona report. The Corona report gave, in its analysis of the importance and dimensions of diversity, an actual example that came from Richard Light's book, published book, which had a particular class. It happened to have 3 African-American students in it. An African-American student gave an answer in a discussion, which another African-American student said, that is not my view. My view is quite the opposite. And a third one said, I wasn't actually going to say anything, but I have a completely different view. That was an incredible learning experience, not only for the non-African Americans in the discussion, but for them. And that's what Harvard is trying to get at.
Thank
I'm
you, Mr.
sorry
Waxman.
for taking so long.
No, I appreciate your answers.
Again, if all of the individual incidents and artifacts that you mentioned were not in this case, and if the university were a state university that never practiced segregation, would you say that the case would come out differently?
It may, Your Honor, and that's how and why we should not have an across-the-board policy that all of a sudden jettisons the important limited consideration of race that this court has approved.
So you would perhaps endorse a system in which a state university in a state that never had de jure segregation would be prohibited from doing what North Carolina is doing?
Yes, because the important point here is whether or not the educational benefits of diversity have been established by that particular university. And so here at the University of North Carolina, of course, it matters a lot because it affects recruitment and retention and the like. But at another university where it may not have been a part of its history, it's still the important piece here is whether or not the university itself can establish its own educational benefits of diversity and satisfy that through narrowly tailored means. The University of Michigan, in the Grutter case, is a good example of that. I won't pretend to know the history of the state of Michigan, and I know that they were fraught with, desegregation problems themselves, within districts, but whether or not that was a remnant of the state's own de jure segregation, I don't know, but that would be a good example.
Thank you, counsel. You've mentioned the benefits, of course, in diversity, but amici on the other side have argued that one consequence of the school's consideration of race is that it sends the message that race is something you should consider down the line. In other ways, student activities, other sorts of areas, that they get the message from the beginning, race counts, and they carry that forward into other areas where there may not have been a history of discrimination that would, in your terms, justify it. Do you have a response to that?
Yes, Your Honor. The research, and there's some of the research that is shown, and I apologize if the court isn't quite getting here, but what I understand the court is inquiring about is, some of the particular stigma that might be attached to...
No, it was the fact that the school is telling students race matters in admissions, and that the students may learn from that lesson that race should matter in other areas where perhaps it doesn't have the same justification as it would have under your view on admissions.
Yeah, so 2 points, Your Honor. One is that there's no evidence in this case of the University of North Carolina's own decision to enact race-conscious admissions had led to any negative consequences, much less the negative consequences that you've shared here.
Do you know, this may
also
be an unfair question, is race a consideration in the formation, other types of activities that students are engaged in? I get the sense from the briefs anyway that race permeates a lot of what happens at the university, and you're shaking your head in a way that you don't agree with that.
Well, Your Honor, it is a bit of reminds me of a storybook when I was a child, Henny Penny and the Sky is Falling argument, because they're blaming that just about everything is caused by race-conscious admissions. But in fact, if you look at the research, for example, on the issue of stigma, both internal and external stigma, and this is referenced in the AERA brief, it actually shows that race-conscious admissions programs at, universities that have race-conscious admissions programs actually have lesser degree of stigma attached, both internal for the student and external, what they're hearing from other students, than states with bans on...
Counsel,
I'm sorry.
I'm not talking about stigma. I'm talking about student groups taking its cue from the university and saying, we ought to take race into account when whatever we're doing.
And again, Your Honor, there's no evidence in this case of how that correlates to any consideration of race at UNC or any other university.
General, if I could move to the merits, let's say that I disagree with you on standing and on the remedies, and I have to reach the merits. And when we get to the merits, I think shall means shall. Then we're in a position where, as you see it, Congress has passed a law that it is impossible for the executive to comply with. Now, it's our job to say what the law is, not whether or not it can be possibly implemented or whether there are difficulties there. And I don't think we should change that responsibility just because Congress and the executive can't agree on something that's possible to address this problem. I don't think we should let them off the hook. So shouldn't we just say what we think the law is, even if we think shall means shall, and then leave it for them to sort that out?
Well, Mr. Chief Justice, let me take a stab at trying to persuade you that these considerations of resource constraints do properly inform the task for this court, which is to interpret the meaning of shall and the statute itself. And the first
Well, it seems to me that you're arguing with one of the predicates to my question, that I think anyway, shall means shall. What do we do in that situation?
If this court were to actually adopt that interpretation of the statute, then I think that it would be incredibly destabilizing on the ground.
Yeah, I didn't ask you what it would be. I want you to know what we should do. Should we still fulfill our responsibility to say what the law is, and then it's up to Congress and the executive to figure out a way to comply with that?
I think if the court did that, and the reason I'm turning to the practical implications here is because in the meantime, while Congress and the executive tried to figure it out, it would absolutely scramble immigration enforcement efforts on the ground. It would mean that DHS, I think, if it were under this kind of judicially enforceable obligation to treat each of those shalls as a mandatory shall.
So you're still arguing, I'm sorry, you're still arguing that that would be wrong to say shall means shall.
I think it would be wrong to say the shall means shall, and I would welcome the chance to explain as a matter of statutory interpretation why that's so. But at the very least, I don't think the court should announce it as a judicially cognizable injury here that could justify interference by the courts in light of the practical ramifications. And they're really two sides of the same coin, because I think one of the reasons the court has recognized that there is enforcement discretion in this area is precisely because of the practical necessity that agencies cannot proceed against every violation of the statute. That's what the court said in Heckler. Or in Town of Castle Rock, the court emphasized that an arrest mandate, if it were truly a mandatory judicially enforceable duty, would be a duty of entirely uncertain scope and priority and duration. It would be impossible to comply with it. And the court said that these background principles of enforcement discretion are a practical necessity.
Counsel, maybe we can move on to individual question now, and I'm sure that some of it will deal with remedy, which is the one area we haven't addressed yet. And in that area, your position on Vacatur. That sounded to me to be fairly radical and inconsistent with, for example, what those of us who are on the D.C. Circuit would do, 5 times before breakfast. That's what you do in an APA case. And all of a sudden you're telling us that, no, you can't vacate it. You do something different. Are you overturning that whole established practice under the APA?
Yes, I acknowledge, Mr. Chief Justice, that the lower courts, including the D.C. Circuit, have, in our view, been getting this one wrong. They have reflexively assumed that vacatur is authorized under Section 706 of the APA. But what I would say is that they haven't reached that conclusion with.
I mean, this is a long. That's what the D.C. Circuit and other courts of appeals have been doing all the time as a staple of their decision output.
But they haven't been doing it with any attention to the text, context, and history of the provision. So it's not as though there are decisions out there that have really engaged with these arguments and come out the other way. Instead, it seems like this happened and came about because courts just reflexively transposed remedies that were available under special statutory review provisions, which do sometimes authorize vacatur, to the APA context writ large. And our argument is that if you actually drill down on the text of 706 and look at its context, and also look at the history of the APA, which was not intended to create any kinds of new remedies, but instead to simply provide for the remedies that had pre-existed the statute's enactment in the traditional forms of legal action under Section 703, it demonstrates that the courts have erred here.
How many cases would you say that we have issued over the past year, decade, whatever, where we have upheld decisions vacating agency rulings under the APA?
The court has
Thousands.
done it in a number of cases. Some of those involve special statutory review provisions, so I do want to box those off. But I acknowledge, yes, the court has sometimes affirmed decisions that
sometimes over and over and over again.
But also never with attention to the remedial arguments that we're making here. And I don't think it's ever too late for this court to give the statute its proper construction when you actually look at its text, context, and history. And I don't think
your Linda R.S. argument under standing, doesn't that mean that no state would ever have standing to challenge immigration policies concerning apprehension or removal of aliens?
That's right. We think that the court articulated a principle there that an individual or a state doesn't have a judicially cognizable injury in seeking enforcement of the law against a third party.
Well, what about Biden against Texas?
The MPP case from last term?
4 months ago. Your position seems inconsistent with that to me.
Well, we did protest the state standing in that case as well. In the lower courts, we litigated that issue, and the Fifth Circuit and the District Court ultimately rejected our arguments. We had also contested the state standing at the stay stage in this court, and the court ultimately declined to grant us stay relief and found that the states had a likelihood of success on the merits. And at that point, we went back to the drawing board and thought hard about these arguments and believe very strongly that the states here lack standing both under the kind of constitutional...
So you went from one argument to believing very strongly the other way?
This has been a through line. We have been protesting state standing, broad theories of state standing in the lower courts. And Mr. Chief Justice, the lower courts have not been accepting those arguments, but we think that the lower courts are fundamentally misunderstanding this court's precedents as it relates to our constitutional structure and the kind of
I would have thought you'd have a little more concern about an opinion of ours that's 4 months old. I mean, it's not even out of the cradle yet, and you're throwing it under the bus.
No.
I kind of mixed the analogies there.
We certainly aren't suggesting that that opinion should be thrown under the bus. We were obviously briefing these issues with multiple mistakes that we thought the district court had made in that case. But I don't think this is a jurisdictional principle, and I don't think that it would prevent the court here from recognizing that the kind of theories of state standing that the states here are pressing and that the lower courts are accepting would really remove every possible restriction that could exist in this space, and that's just fundamentally incompatible with both constitutional structure and the separation of powers.